Good morning, everyone. It seems like this morning, everyone just right on cue was like, okay, we're ready. So, good morning, everyone. I want to welcome everyone to Assembly Judiciary. Welcome everyone here in Carson City and anyone watching online or through Nellis. With that, Secretary, please take the roll.
Assemblywoman Bilbrey Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Ornlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick.
Here.
Chair Miller.
Here. And with that, please mark any members that aren't here yet present when they arrive. With this, we will go ahead and get started. Just a friendly reminder that to please turn down the volume on anything you have that could be disruptive during the hearing. We will have public comment at the end of today's hearing. Today, we only have one bill on the agenda, and we're going to get started right away because Assemblywoman Torres has to go back and chair her own committee right now. So we have one bill. The bill is Assembly Bill 244. It's presented by Assemblywoman Torres, Attorney Allison Brazier, and Attorney George Buchanan. And you will correct me when you get up here if I said that incorrectly, please. So with that, I would like to open up the hearing. Assembly Bill 244 revises provisions related to certain mental or physical examinations. And so I'll give you a few moments to get settled in. As I said, Assemblywoman Torres is going to start off the hearing, and then she's going to chair Government Affairs. So with that, please proceed when you're ready. And please correct me with, sir, how do you pronounce your name? Good morning. Buchanan. Okay, thank you. Buchanan, thank you so much.
Hi, good morning. Assemblywoman Selena Torres for the record, and I proudly represent Assembly District 3 in the heart of Las Vegas, Nevada. Today, I am honored to be here today to present AB 244, which is making some changes to the NRS regarding legislation that we actually passed out of this committee when I sat as a member of this body in 2019. I'll be honest, this particular bill is very specific and detailed, and so I'm very fortunate today to be here with two phenomenal attorneys from our great state, Mr. Buchanan and Ms. Frazier, and they're going to kind of carry on the presentation from here. That being said, I'm very familiar with the legislation. I'm happy to have conversations with my colleagues outside of this chamber room. If you have any questions, I'm happy to continue to work with you all to answer those. We also know that there have been some issues raised from various parties, and we will continue to work with stakeholders to address some of the concerns. Thank you. And with the chair's permission, I'll return to my committee.
Yes, thank you so much, Assemblywoman.
Good morning, Allison Brazier on behalf of Nevada Justice Association for the record. AB 244 is a bill that deals with rights for individuals who are compelled to attend examinations, physical and mental examinations with a doctor with whom they have no doctor-patient relationship, and it's not for treatment purposes. So these are examinations that happen solely for evaluations, most of the time by insurance carriers, by licensing agencies that require medical examinations for some type of license. So again, these are not the normal, you go visit your doctor because you want to get treatment, you want to get help with something that's wrong with you. These are non-doctor-patient relationship examinations that people in the state of Nevada are being forced to go to if they want to receive benefits or enforce rights that they have. Again, these are things like disability insurance examinations, examinations if you're making a claim against your own insurance company to get benefits that you've already paid for, licenses like a pilot's license where maybe it was suspended because of a medical condition, now you're having to go back in to get an examination to reinstate your license, also workers' compensation examinations. These are things that a lot of people maybe have never been through, but in our world, they happen every day to citizens in our state under these different circumstances. Some things I want to clarify. This, again, this is not doctor-patient relationship examinations. We're not intending it to include examinations that might happen involuntarily for mental health reasons or for public safety reasons. That's not what we're intending to include in this bill. It's the examinations that are being compelled by insurance companies, by licensing boards, for which it's just evaluation, no treatment is occurring. As Assemblywoman Torres mentioned, a similar bill was passed back in 2019 out of both houses, became law on a bipartisan method, and that became NRS 52380. That went up to the Supreme Court, and the Supreme Court felt that that statute invaded their territory a little bit too much with dealing with procedural issues. And so when we got that decision back from the Supreme Court, we took a step back and said, you know, our intention was really to protect people's rights, their substantive right to bodily autonomy. And what rights and what protections do people have when they're being compelled to go to an examination? And so AB 244 is not about procedure, it's about rights that are covered for all citizens in various situations in and outside of the courtroom. So this is about the substantive rights, it's not about court procedure. And as we've outlined in section, it's the subsections 1A through E. Those are the protections that we feel individuals in this state should have when they're being forced to go to these examinations. The first one is notice, so that you can make sure that you're prepared and ready for the examination. Second one is an observer of your choice. This happens, you know, every day when people go to important medical examinations. A lot of people feel more comfortable if they bring someone with them, not only to be able to maybe remember what happened after the exam, for comfort, for safety, to help them understand afterward, hey, what was the doctor actually saying? What went on? In the context of like workers' comp evaluations or examinations that happen in the context of civil litigation, a lot of individuals feel comfortable bringing like a nurse practitioner with them to help them understand what were those tests that the doctors were doing, what did all of that mean. So section number 2, or B, which is observer of your choice, is something that we normally do in everyday life, but we want to add that protection in during these compelled examinations. The third one is straightforward, to have an interpreter present if you feel like that would assist in the examination. The fourth one is to be able to take notes during the examination. And then the last one is to be able to record the examination. Again, so that there's an objective record of what happened. And that's really a protection for everyone involved, for the person who's being examined and also for the doctor or other medical professional who's performing the examination. If there's any question, we have a record, we know what happened. And these are all rights that if someone doesn't want to enforce them, if they say, hey, I'm fine going without recording it, I don't want to do this, they don't have to do this. But we're in this bill, we're providing the right to the person, and it's their decision if they want to exercise that right or not. So you know, there was some concern that, oh, are people going to feel comfortable if things are being recorded while they're being examined? And again, it's optional for the person, but we want that right to be in statute so that people can enforce it if it's something that they feel more comfortable with. So that's what the bill says. I'm going to turn it over to Mr. Bochanis to give you some examples about how some of these things are already occurring within our state and other states.
Good morning, Chairman and Chair and members of the Judiciary. I'm George Bochanis. I've been an attorney here in our great state since 1982, and my practice involves solely personal injury and worker compensation matters. And I'm very proud to set forth this bill for you all this morning. I like to call this bill the Compelled Examination Fairness Act, because what it does, it promotes fairness and transparency during these compelled examinations. Now, when you hear compelled examination, it sounds like it's something that's being forced on a person, and it is. These are exams that a person is compelled to attend because of a policy provision. here's a great example. When a person wants to apply for disability insurance or health insurance, oftentimes your company requires an examination. So our position is, that's fine, that's something that's compelled, that's something that's required, but that's something that you should be allowed to bring an observer to, and that's something you should be able to record. And who does that benefit? It's our position, this benefits both the person that's being compelled or forced to that examination and the doctor. It protects both parties. You know what's happening and occurring during these types of examinations, and as a result of that, you have both transparency and you have fairness. So that's a perfect example of a compelled examination. I think there's a little confusion, and when I read the LCB summary, there was a lot of emphasis on the prior statute and this Supreme Court decision since then. The prior statute and what's being presented to you today are two different animals. This is far broader application. The previous statute had to do with one circumstance in our Nevada Rules of Civil Procedure. This involves things that are outside of civil discovery, outside of any lawsuit situation. It's something that is far broader, and that's why it involves a substantive right. A person being able to protect what happens to them, basically their body, during an examination with a doctor they have no relationship with whatsoever. This bill protects that person, and we feel likewise it protects the doctor for what occurs. Imagine a doctor stating something in a report that a patient doesn't recall stating, I shouldn't say patient, that a person doesn't recall stating during the exam. Well, having another person present and having a recording of that examination prevents those types of problems. So that's why it's fair to both parties involved in something like this. I've been practicing worker compensation law, as I said, since I opened my office, so we're talking 37 years. In worker compensation cases, for that period of time, when an exam is compelled during worker comp, you're allowed to bring anyone you want as an observer. And I can tell you that in 37 years, there hasn't been a problem with this type of an arrangement. You've never seen, as this body, people coming up to you and saying, you know, the fact that worker compensation claimants are allowed to bring in an observer has created all these issues and problems. Nothing. It's been totally non-problematic. And it's our position that this is also going to create no problems, but instead promote, this substantive right is going to promote both fairness and transparency. Additionally, other states allow these types of observers during examinations. I did a survey during the last session, and it was well over 20 states allowed observers of any type at most of these types of compelled examinations. So again, we're not promoting here anything that's unique or different or out in left field. This is something that, first of all, has been occurring in our state for decades, and it's something that's been allowed in other states across our country. And it's very important, and I can't state it enough, as this creates a substantive right. This is outside of any civil, outside of any type of civil discovery procedure. This goes beyond it. So in closing, I just want to let all of you know that we are working with other stakeholders with any issues that they may have that are kind of on the fringes of what we're seeking to do with this bill. And we thank you all for your consideration on this, and of course we'd love to take any questions that any of you have. So thank you very much, Chair.
Thank you so much for your presentation, and I'm glad you said that because there are quite a number of questions that we have today, okay? So first question, we will begin with Assemblywoman Newby.
Thank you, Madam Chairwoman. This bill kind of reminds me of when my mother was going through cancer, ultimately passed away, and it was necessary for me to go to the doctor with her to better understand what was going on. And I can't imagine what would have happened if I had been turned away. have there been instances in which people have gone to these examinations with a loved one or a friend or someone else to help interpret and remember what the doctor's directions were, where they've been turned away?
Chair, through you to Assemblywoman Newby.
Please go direct.
Okay, thank you. Allison Brazier for the record. Yes, there have. It's currently an issue right now about whether nurse observers can come to those examinations. But we have had other situations where the doctors either I shouldn't speculate why, but have turned away someone from attending the examination. And similar to what you're saying, when it's a stressful appointment that you're going to, and this is a much different context because, again, it's not for treatment, but it is a stressful situation because people are going there and they know that this doctor is examining them to make a determination if they are entitled to either benefits that they've paid for or to reinstate a license so that they can go back to work. That's a stressful situation. And so it's our position that it's very similar to the experience that you were sharing where it's stressful. People, when they walk out of stressful doctor's appointments, sometimes say, I don't even remember what just happened. What did the doctor say to me? And so if we would do that in normal life, why wouldn't we give that same protection to people who are simply trying to exercise their right? And again, it's about this invasion of our bodily autonomy, right? That we should be able to go to doctors who we feel comfortable with and for treatment purposes. And when we're forcing people to do an examination under other circumstances, I think we should give them the same rights that we would if we were helping a family member through a tough medical situation.
And let me just add this to Assemblywoman Newby, and our condolences, obviously, to you. This situation that you just described highlights to us the importance of allowing observers at these types of examinations. I can't think of the person's state of mind that is being subjected to these types of examinations not being allowed to have a loved one or advocate or someone protecting their rights during these examinations. And that's why this bill is such a substantive right and so important, I think, for your consideration.
Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair, and thank you for being here. Madam Chair, I think I have a couple questions. This is really quite complicated, so
Can we, just for the sake of time, start with one at a time and
Okay.
then I can return? Thank you.
Right. In 2019, the bill, in a different form, passed, was overturned. So could you explain to us, and I was here for that, could you explain for us, because you mentioned that the Supreme Court felt that this was getting a little bit into their territory in the courts. So could you kind of explain for those who weren't here in 2019 to understand what are the differences of that law versus what this bill is trying to do now? And then if I'm allowed later, I might have another one for you. Thank you.
Yeah, thank you, and we appreciate that question, and I think it's a great point to kind of highlight the differences between the two. The prior NRS 52 that was overturned by the Supreme Court had to do with one Nevada civil procedure section, and that was Rule 35, and that was it. It applied to that one rule. And the Supreme Court said, well, if you're going to make a statute regarding one NRCP, Nevada Rule Civil Procedure, that you're kind of invading our province. And it's happened to bring the case to me because I kind of thought this was going to come up today. Basically what they said was outside of civil discovery, that statute had no application. So this bill that we're presenting to you today has many applications outside of civil discovery. It has to do with examinations for disability insurance, which have nothing to do with civil discovery. It has to do with examinations for health insurance, nothing to do with civil discovery. It has to do with, Allison mentioned, it's a great point, a pilot examination. That has nothing to do with lawsuits. It also has to do with if you have an auto insurance policy and you want to receive what's called medical payments benefit or underinsured motorist benefits, your insurance company and every one of your policies has a provision that requires you to submit to an exam by a doctor chosen by your insurance company. You have no choice in who that doctor is, and you have no say in how many times you're examined. That's outside of the civil discovery process. And again, this would apply to those types of situations also. So it's become an apples and oranges type of comparison from the prior statute to what we're presenting with you today. Supreme Court also said that the only relief a party can obtain under the previous statute is a protective order under the Nevada Rules of Civil Procedure. Well, we took care of that by Section 3 of AB 244, where it provides an entirely different, I'll call it, I think the best way to describe it, it creates a causes of relief if this AB 244 is violated. That wasn't present in the prior statute. So again, and that's why I appreciate the question, Assemblywoman Hampson, it's two entirely different situations. This is far wider and broader in scope. The prior statute had to do with just one rule of civil procedure. And I hope that answers your question in kind of a long-winded way. I tried to keep it as non-lawyerly as possible.
Thank you. Next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you all for your presentation. You mentioned that these are examinations that are compelled, meaning that they are demanded by someone for us to, or someone to go and see a doctor. These particular physicians, are they general practice? Are they specialized folks who are whose business model is to conduct independent examinations? Can you explain that?
Allison Brazier for the record. It depends. Depends on what type of examination is being performed. But more and more in the civil context, we're seeing that it's doctors who the majority of their income is coming from doing these examinations. And again, I think the important part to I guess, emphasize is that these are doctors where there's no doctor-patient relationship that's established. So it really could be an array of different doctors. But in the workers, at least George can probably speak more to that, but in the workers' compensation system, it's doctors who are specifically applying to be on that panel to do these exams.
Thank you. Can you talk about the range of, is there a set price or cost that goes along with these types of examinations? And how often do the same people end up showing up conducting these exams? Thank you.
Thank you. Allison Brazier for the record. I've seen, just for the examination, I've seen the charges range, probably on the low end, I'd say $7,500, but I've seen bills that go $20,000, $30,000 with the examination and records review that go along with it. So it's not, you're going to the general practitioner and it's a $250 exam and, going on your way. There's many, many doctors in this state and also in California who are licensed here who make millions and millions of dollars doing just these examinations.
George Bochanis again, and I guess I would also add to that, we've seen bills from these doctors with many of these compelled examinations. I've never seen an examination and a report for less than $5,000 to $10,000. That's per report. And we've had testimony from doctors that one could say specialize in these types of compelled examinations, and I've never heard of them earning income less than $300,000 to $400,000 a year conducting these types of examinations. And that's, I would tell you, that's the low end of the spectrum.
Thank you for that. Our next question will be from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for presenting today. So I was very happy to see interpreter included in there. I teach at a school where many of my students' parents don't speak English. We have a student currently that has very serious illness that is not getting treated because when she goes to the doctor, she has to be the translator for her parents, and that causes all kinds of issues with their home care. And so I just wondered, can you speak to that issue and let us know, are people being prevented from having an interpreter now, and what kind of ramifications result from that?
Allison Brazier for the record. I haven't seen it just in my own experience in the civil world. I haven't seen it where they're being prevented, but we wanted to make sure that it was enshrined as a right, so that if it ever was challenged, that it would be there and the protection would be there for many of our citizens, similar to what you've been explaining.
And George Bochanis, just to add on to what Allison said, we looked at this section as kind of preventative maintenance. We want to make sure that that those members of our society are protected, and that there's no issue whatsoever involving the need for, if there's a need for interpreter, we wanted it in there in writing just to make sure. And so that's the main purpose of that section.
Thank you. Our next question is from Assemblyman Gray.
Thank you, Madam Chair. So the intent is to protect the patient in this case, and I'm wondering why you guys didn't include a provision in here where to prevent bias upon the examiner, who's obviously representing the compelling party, to allow the examiner to be a mutually agreed upon person between the patient and the party, like you do with arbitrators, or you usually get a list and can select. And then the other thing is why are the damages? I mean, not the damages. Why is the fine so low? I mean, you would think to keep somebody from violating somebody's rights like this, you would actually have a punitive fine, 10 times that amount.
George Bochanis, for the record. Great points. So first of all, as far as being able to choose a doctor, a lot of times this is a private contract that compels it, and the person signing that private contract, like an insurance policy, has no say in the terms of that policy. And so that's why this bill is necessary, because the person that's being compelled is starting from a position basically of weakness. This is a policy that they had to agree to, and they don't have any right to negotiate the terms of that policy. And that's why they don't have the right to choose that doctor. Perhaps a subject of future legislation, that's something that to be considered, but that's why there isn't that right to choose, and that's why this bill is really necessary. Your second point, with respect to the dollar amount, we wanted to try to make this as palatable as possible to everyone across the spectrum, and so we purposely didn't go probably as high as we could have. Of course, we'd be open to suggestions from this committee as far as raising that amount, and we'd of course be open to it, but we tried to make it something that would be acceptable to as many people as possible, and didn't want that to be a factor of people not supporting this bill. But those are points that we thought about a lot and appreciate the commentary.
Thank you. Our next question is from Assemblywoman Constantine.
Thank you, Madam Chair. And I know this has been touched on a little bit, but I just wanted to ask, looking at this, you have both mental and physical, and we're talking about people of all ages. And having someone, I'm thinking of a senior who's going to one of these compelled examinations, might already be nervous, if this is an examination that includes, a mental examination, whether or not this person that can be in the room with them, who is, I'm assuming, there to help them stay calm and just to have that other person there is sort of grounding them. Are they just in the room, sort of just observing? I'm assuming that they don't answer questions for anyone, but they're just there to kind of help that person who's in an unfamiliar place, having someone unfamiliar asking these questions, if that is kind of the purpose for this. And I'm thinking just specifically seniors.
Allison Brazier for the record. Yes, we've dealt with this, already before this bill came up, as far as the mental examinations, because there was a concern about having an observer in the room, and does that affect the testing? We have had compromise kind of situations where the observer comes, but during the actual testing sits behind kind of like a one-way glass, so that they're not affecting or trying to, encourage certain answers or affect the person's responses to things. So there are definitely workarounds to address any concerns that the observer might be influencing the examination. But I think, again, to your point, seniors are a vulnerable population, right? People who are going for a mental health exam, or people who have a traumatic brain injury, those are also our vulnerable populations. And so that's why we really want to put these protections in, and to include the mental health part of it too, because, we interact with a lot of clients who have TBIs, and if they were just to go into an examination, there's no observer, there's no objective record of it, and they say, oh, I don't remember that happening, and you have a doctor who says, well, it did, how's that going to weigh out? And so again, kind of like what George was saying, this is kind of the Fairness Act, right? To level the playing field for our vulnerable people who are being examined, so that we can make sure that things happen the way they're supposed to.
George Bochanis for the record. Also, I think it bears importance that why would you not want an observer in one of these examinations? If a person is telling you that an observer shouldn't be at one of these forced or compelled examinations, what's the motive of not having an observer at this? What's the motive in making sure that what occurs and what's done at these types of examinations isn't out there on the record? I mean, this is what the transparency portion of this is about. Why would you not want an observer or recording of these types of examinations? What could be the possible motivation? And observers also come in different forms, as we talked about too. An observer is there potentially for emotional support over a stressful situation of being compelled at an examination like this, or an observer can be a professional, like a nurse, to make sure that the examination is conducted in a certain manner and way, and it's properly done. So the observers take various forms, and observers are really necessary if the person wants one for this type of substantive right. And that's why this is a Fairness Act. Thank you.
Assemblywoman, did you still want that follow-up?
Yes, please. It was just quick. We hear a lot of acronyms in here, so just wanted to make sure. TBI, is that traumatic brain injury?
Yes, I'm sorry.
Thank you.
Thank you for that clarification. Our next question is from Assemblywoman Gallant.
Thank you, Chair. So I'm curious about the 21 days and how that would play out with somebody that, say, is detained. Maybe they're possible harm to themselves or others, like a suicide watch, and insurance now needs to do some type of exam. Or maybe they're detained like in custody, and there needs to be some type of mental exam before they can be released or put into a proper... Would that fall under that? And then would they have to wait those 21 days before they could have that exam?
Allison Brazier for the record. Just, I guess, to kind of hit the first part about would they have to wait. These are all rights that the person can exercise, right? So we're not saying you have to wait 21 days to do it. But if it's going to be a compelled exam, then you have the right to do that. But so I just wanted to say that before I say this is not intended to cover those situations like where it's a involuntary examination because of mental health or safety threat, and we're, holding someone 72 hours for an evaluation. We have had some concerns about what would happen in the criminal context, and so we're going to work with those stakeholders to craft an amendment, because we're really, the intent is to provide substantive rights to individuals, but it certainly isn't to invade any kind of public safety or individual safety concerns that law enforcement might have.
Okay, thank you. Our next question is from Assemblywoman Hardy.
Thank you, Chair. So I think it might be helpful if you could just give us a definition of what substantive rights is. It's been mentioned quite a bit. And then also in here, in B, it says any other person hired. So I'm just wondering, does the observer, the interpreter, somebody taking notes, it all has to be someone that the individual hires, or can it be a family member? Or, would that still, if you could clarify that, thank you.
George Bochanis. Let me take the easy question first, and then I'll grapple with the second one, with a little bit more legal one secondly. So yes, the person that's being compelled for the examination has the right to hire or retain an interpreter, a nurse practitioner, any other type of observer that they would want. Now, keep in mind, the observer isn't there to get involved in the examination, and that's why they're called an observer. But they are there to observe, to basically watch what occurs, how things are done, and things like that. And so, yes, that person has that right to retain any of the above, that whole spectrum of different types of observers that this type of an exam would involve. Let's get to the substantive right, because have you noticed we've said that more than once? The Supreme Court of the United States of America has stated that a substantive standard is one that creates duties, rights, and obligations, while a procedural standard specifies how duties, rights, and obligations should be enforced. So what happens to a person and how a person is examined is a substantive right, and that's why this AB 244 involves those types of situations. And this is what happens to a person's body basically this is what's happening during these examinations. That person's physical or mental state are being subjected to an examination by a doctor that you have no doctor-patient relationship with whatsoever, that you have no choice with who's being examined, that you're in an examination room with. That's a substantive right. And our Nevada Supreme Court said it was important that a substantive right creates a claim for relief if you violate that substantive right. And that's why we have Section 3 here, because if you violate this substantive right, there's a price that comes with it. And as Assemblyman Guy said, maybe $1,500 isn't enough. But that also covers that type of section. And this doesn't have to do with civil discovery. This has to do with things outside. It involves things inside and outside of our civil discovery system. And of the examples we gave you with the disability exam, health insurance exam, your insurance policy, medical payment or uninsured motorist exams. So I hope that answers your question. Thank you.
Thank you, Assemblywoman. Our next question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. Similar to my colleague, I was going to ask a question around 1A about the 21 days. Currently, do we give notice? And we know that hourly workers, they can't just get off work so easily, so wondering about the notice we currently give.
Thank you, Allison Brazier, for the record. In the civil litigation system, we often work, with the courts or work with the other attorneys to come up with a mutually agreeable date. Because like you're saying, most of our clients are hourly workers. They can't just take off a moment's notice for work. But again, because this bill expands to rights in any context, that's why we wanted to put that 21-day notice in to provide people the opportunity to either take time off of work or do whatever they need to do so that they're available for this examination. So outside of the civil litigation context, there really is no, unless it's prescribed by maybe the contract. There isn't a time frame. I should clarify when I'm saying civil litigation, maybe that wasn't specifically the right word. In workers' compensation, we do have some time frames. They're 10 and 15-day time frames that we've heard from the workers' compensation people that we might need to add an amendment to make those two, this statute or this bill and those existing timeframes work cohesively together.
Our next question is from Assemblyman Ornlicker.
Thank you, Chair, and thank you for bringing this bill. I think you, Mr. Bochanis, said that you've had lots of experience with this kind of a right. Bring in, is it in workman's compensation? And we've had also
Yes.
experience in other states. And you're, from what we know, with implementation of this kind of a right, it's worked very well. Is that, am I remembering that correctly?
George Bochanis, for the record, yes. Yes. In the worker compensation context, whenever a client concludes his worker compensation case, that person is then entitled to a permanent partial disability evaluation if that person has any signs of permanent impairment after they finish treatment. So I would say my office has had over 1,000 of these over the years, and we send either a family member, a member of my office. We've had nurses attend some of these exams at times. We have had not one problem with an observer at any of these types of examinations. And this procedure has existed in the worker comp system before I came along. So I'm comfortable in saying it's been 50 or 60 years that this type of procedure has been allowed in Nevada in worker compensation cases. And this legislature has never seen one bill or any type of complaining of any type regarding observer at these types of examinations. So it begs the question, obviously, well, why would there be a problem now in this context? Thank you.
Thank you for that. We have, we're going to return to Assemblywoman Hanson. She has one more question.
Thank you, Madam Chair, for that. And actually, you just kind of got there a little bit with what I had wanted to have clarified earlier. If we're doing this in workers' comp, kind of what is the difference? But as I refer to my notes from 2019, and this might be answered from testimony, but maybe if you could address it too. I had a note that one of the concerns had been that with the observer, who's supposed to observe and not get involved and not have confrontation, but there was a concern for that it wasn't perhaps not fair that defense counsel could not be present at the examination, only plaintiff's attorney. Is that an issue? It was brought up in 2019 because that maybe sometimes there could be some sort of confrontation. It sounds like from workers' comp that doesn't necessarily happen, but I just know that was kind of a big deal in 2019 by my notes, and just wondering, are we still having that kind of pushback with this newer version, broader version of the bill?
George Bochanis, for the record. As you know, I was here in 2019 on that bill, and yes, that was an issue. The way we responded it back in 2019 was the fact that, well, the defense already had a representative in the doctor who was, I'm going to not say doing their bidding because that's too harsh, who was selected by them already, and so that doctor was well representing any rights of that entity, and that's why an observer was actually necessary to kind of level the playing field so that you had the doctor that was the employee of the compelling party, and then you'd have someone there basically just observing for the rights of the person that was being subjected to the compelled examination. This bill now goes beyond that in that it creates now, this is now a subject of examinations outside of litigation, outside of legal cases. It includes them, but it goes way beyond those now too. And so it's our position that the same arguments remain and our same response remains. And this goes beyond, like I said, those types of that one situation we had with the prior bill. This, to compare the two is just, it's not accurate. It's just not accurate. And so, and that's why it's still necessary. And that's why it's a substantive right, because we're creating the right to have an observer and to have recordings there during these compelled examinations.
Thank you for that.
You're welcome. We also have one final question from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. So I want to talk about compelled mental and physical examinations under Title 11, because that's where domestic relations live. And we do have them, but those are much different situations. Is this bill intending to capture that, or are we going to be seeing a carve-out amendment coming, or where are we with that?
Yes, Allison Brazier for the record. I actually had that written down that I intended to mention that in my presentation, so thank you for bringing it up. Yes, we do intend to work on an amendment language that would address examinations of minors that occur in the family law context, because we recognize that there are different interests at stake in that context. So we will continue to work with the Assemblywoman and with the Domestic Committee to make sure that language addresses concerns in that context.
Okay, thank you for that. And then also, would that include litigants, adult litigants in the domestic space as well, because they do have, they can also be compelled to have examinations. So it's not just minors, it's also the adults, like parents in a custody dispute, that type of thing.
Yes, Allison Brazier for the record. Yes, I mean, we're, like I said before, you know, we don't intend for this to kind of stray into, you know, the criminal context where there's safety concerns, into the family law context where there likely is a lot of safety concerns or mental health concerns if an examination is being compelled. So we are definitely open to the continuing conversation to make sure the amendments alleviate concerns in those areas.
Thank you.
Thank you, and I actually have one final question for clarification. So before you stated that doctors can receive, on average, between $7,500 upwards to $30,000 for an examination based on the type of examination, obviously. And I'm understanding that this is paid for through, obviously, that insurance company or whoever, that they're paying the doctors for the exams and the reports. I'm curious because it doesn't necessarily address it in here, but going forward, if an individual was able to have an observer or an interpreter with them, would those companies also absorb that cost for that recognized observer? Or, you know, because again, it could be a professional nurse, it could be a language interpreter, whoever, who would cover those costs for that individual?
Allison Brazier for the record. Traditionally, it has been borne by the examinee, especially if you're going to hire a nurse observer. You know, we're not trying to pass those costs along to a different party. If you want to exercise the rights, traditionally it's been the financial responsibility of the person to put in those safeguards.
Okay, thank you for that. With that, I will go ahead and open it up for testimony. I ask that, first let me give the phone number for those that are intending to call in. The phone number is 1-669-900-6833. And the meeting ID for today is 882-464-05764. So we will open it up for testimony in support of AB 244 here in Carson City first, and then we'll go to the phone line. Again, I ask that people, we believe there's a number of people that want to testify, so if we could keep it to around 2 minutes. And with that, if there's anyone here in Carson City that would like to testify in support, please approach. Okay, broadcasting, is there anyone on the line that would like to testify in support of AB 244?
Callers, if you would like to testify in support of Assembly Bill 244, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 244, please press star 9 now. Chair, there are no callers choosing to testify in support at this time.
Okay, thank you. Then I will open it up for anyone who would like to testify in opposition of Assembly Bill 244, beginning here in Carson City.
Good morning, Chair and members of the committee. For the record, Paul Muratkin with the Vegas Chamber. The Chamber is in opposition to Assembly Bill 244, which is based on feedback we have received from our members, who are concerned about the adverse impacts it could have on businesses that are defending themselves in civil lawsuits. Our members are concerned that the bill would allow for private right of action against anyone who allegedly violates the provisions of the statute. They also have expressed their concerns that this litigation would allow the plaintiff's attorney and their plaintiff medical experts to attend the examination as well. They also have concerns that the bill would dissuade defense experts from participating. And our members also believe that if AB 244 passes, that doctors may be sued by the examinees. These are some of the concerns our members have shared with us with the bill, and we appreciate the committee's time and consideration today. Thank you very much.
Thank you. Is there anyone else here in Carson City?
Thank you, Madam Chair, committee members, Misty Grimmer, with the Ferraro Group representing the Nevada Resort Association. In the interest of time, for the most part, I'll say ditto to what the Chamber just said. We have the same concerns. We also have, we want to look further into what the ramifications of moving what is a civil procedure into the Chapter 629, which relates to the overall practice of the healing arts and what broader ramifications that could have. And so we continue to look forward to working with the bill sponsor, and thank you for your time.
Thank you. And even though the bill sponsor is no longer in the room, I'm sure she's looking forward to continue working with you as well. Is there anyone else that would like to testify in opposition of Assembly Bill 244 here in Carson City? Not seeing anyone. Broadcasting, is there anyone on the line?
Callers, if you would like to testify in opposition to Assembly Bill 244, please press star 9 now to take your place in the queue. Again, if you'd like to testify in opposition to Assembly Bill 244, please press star 9 now.
As for the record, Dr. Chapel Love, I am representing as the president of the Psychological Association. I appreciate the chair and the committee's time this morning. I did want to offer on behalf of the Nevada Psychological Association a few points in reference to AB 244 this morning, providing more protection for the examinee. This is, of course, specific to the psychological aspects of, in particular, forensic testing, whether a person be within custody or without custody. Certainly, like a 21-day notice may not be full, as well as a safety concern in particular for people who are currently incarcerated. Any observer, I think a really important point, observer with
Excuse me, could
potentially
you,
even saying,
can you hear me?
yes.
Doctor, the connection is really poor on our end, and it's coming in and out. Would you mind maybe trying calling back, because we want to make sure that everyone's hearing what you're saying, and it's kind of in and out on us.
Oh, my word. Oh, my word. So sorry.
No,
It
no,
will-
that's technology. It's fine. If you could try to call back.
All right, I appreciate it.
Thank you. Call right back, and we'll let you back in, okay?
Thank you.
You're welcome. Broadcasting, is there...
Callers, if you'd like to... My apologies, Chair. Callers, if you would like to testify in opposition to Assembly Bill 244, please press star 9 now to take your place in the queue. Again, callers, if you'd like to testify in opposition to Assembly Bill 244, please press star 9 now. Chair, there are no other callers choosing to testify at this time.
Can we just wait a few
The
moments?
other caller has not joined.
Okay, let's just give it a moment and see if the doctor's able to get back in. And then, if not, we'll just accept the doctor whenever they are able to get back in, okay?
Okay. I have one other caller that just joined that would like to participate if you'd like me to move on to that one in the meantime.
Yes, please.
Good morning. This is Dr. Chapel Love again. Am I being heard at this time a little bit better?
A lot better. Thank you. Proceed.
Oh, my word. Thank you very much again, Chair, for the second chance here today. I will try and keep it brief as I want to be mindful of everyone's time. My name is, for the record, apologies, Dr. Lauren Chapel Love. I'm the current president and speaking on behalf of the Nevada Psychological Association. We're a group of psychologists within or throughout the state of Nevada. So we value very much the opportunity to be able to speak relating to AB 244. Unfortunately, we do have some pieces of feedback. We are hoping to work with everyone as stakeholders, of course, and just wanted to speak to the specific feedback. So the existing statute likely provides more protection to the examinee and examiner at this time, and that's, of course, speaking to the psychological components of any type of examination, in particular forensic. I, for example, am a psychologist in the state that does forensic examinations, oftentimes with people who are in custody. A 21-day notice may not be feasible and could conflict with legal holds and other safety regulations that are there to protect facilities, as well as, of course, the people inhabiting the facility at the time. Any observer might make even a small comment such as, hey, you can do this, or you know this answer, which unfortunately for a lot of psychological testing really impacts, if not invalidates, results. So speaking, of course, like to the motive or what's the utility of wanting, potential limitations for observers, I think some of those considerations can be brought up in our hopes to have, a meeting with Assemblywoman Torres and other people who are, involved with this bill. Any observer, of course, without limitation is a significant problem, as it will likely impact the way a person responds to questions and overall validity of the answers, while, of course, we're trying to encourage comfort and relative safety within any type of testing facility, especially if a person has a friend or a family member, and also with regards to an interpreter. The examiner is ethically already obligated on the psychologist license side to have an interpreter if needed, where we, the doctors, are being required to provide them and not the examinee. So leaving this up to the examinee can, again, potentially create problems with validity for testing, which is, of course, the entire purpose of our meeting with them. So taking notes, recording the examinations can also jeopardize testing security, which are big concerns, of course, on the psychologist side. as there are no legal safeguards as to how the notes and/or recordings will be stored, will be used. That, of course, the major concern being protecting confidentiality of the evaluee, and if taken by someone, not ethically bound to confidentiality. So typically already, lawyers might be allowed in some of the examinations, and those are examples of people who are already ethically bound for confidentiality. So in closing, the repealed section, there were safeguards as to the disruption of the examination, and if it's taken out, it may allow an observer to disrupt a coach or otherwise interfere with examinations. That's all I had for today, and we look forward to meeting and discussing any potential feedback, because it is our hope that this can really be able to help Nevadans, and definitely want people to feel safer in these evaluation rooms. Thank you for your time and the continued consideration for my technology
Yes.
issues here today.
Thank you so much. Broadcasting, is there anyone else on the line?
Yes, Chair, one moment. Caller with the last three digits, 047, you are unmuted and may begin.
Madam Chair and committee, my name is Matt Walker. I'm a Deputy City Attorney with City of Las Vegas. I think Dr. Chapel-Love hit on a lot of the same concerns we had, and it sounds like, in listening to Attorney Frazier, the bill sponsors are well aware of the public safety concerns and the forensic in the context of forensic examinations. I just wanted to weigh in and basically second what Dr. Chapel-Love said. We've got concerns about public safety considerations for observers in correctional facilities, as well as the security of the production as such with the bill in the form that has been drafted.
Thank you for your testimony.
Callers, if you had recently joined and would like to testify in opposition to Assembly Bill 244, please press star 9 now. Chair, there are no other callers to testify in opposition at this time.
Thank you, Broadcasting. Then with that, I will open it up for testimony in neutral here in Carson City. Not seeing anyone that would like to testify in neutral. Broadcasting, is there anyone on the line?
Callers, if you would like to testify in neutral for Assembly Bill 244, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in neutral at this time.
Thank you for that. Then I would like to welcome up the bill presenters for your final remarks.
Thank you, Chair. George Bochanis. So first of all, I think we were clear, and Allison Brazier was very clear, the intent of this bill is not to involve incarcerated individuals or matters within the criminal justice system. I don't know how else to describe that except by just stating that very clearly. And the final remark I would have is that when considering this bill, I think it's very important that if you see that this bill is appropriate and serves a useful purpose, which we feel it does, that this bill is recognized as a substantive right. It's very important that this is part of the record of your deliberations. And as I stated earlier, a substantive right is one that creates a right that isn't there right now, and that's what this bill does. It creates a right for a person that's subject to a compelled exam to have an observer and to have that examination recorded. And those are the rights that this bill creates, and that's what causes it to become a substantive right as opposed to a procedural one. And I think that's very important in the event that this is reviewed at a later date, this bill, if it's approved and it's reviewed at a later date, that the fact that it's a substantive right is part of any deliberations about it. And we appreciate everyone's time and attention, and the questions were excellent and appreciated also. And if I can answer anything else, I'm more than happy to.
Thank you so much for that. And with that, I will go ahead and close the hearing on Assembly Bill 244. Next, we have public comment. So if there is anyone here in Carson City that would like to approach and make public comment. Not seeing anyone. Is there any broadcasting? Please open the lines if there's anyone that would like to make public comment on the phone line.
Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Marshall County Sheriff's Office during a mental health crisis. I would like to urge you all to read the legal filings and the ongoing public records lawsuit that This Is Reno has filed against the city of Reno. There's links to the hearing that took place on 3/7/23 available on our Nevada Judge's YouTube page. Though the complaint lays out numerous examples of how the city of Reno skirts the public record laws, I will highlight one in particular, as it is the MO used over and over when police use deadly force in Nevada to suit their narrative and skirt transparency and accountability to the community. This is in regards to denied requests for body-worn camera footage. I quote the complaint. The city claims it never releases similar records it has denied to This Is Reno, such as body-worn camera footage when investigations are open and ongoing. This is patently false. The RPD regularly publishes on its YouTube page critical incident summaries featuring body-worn camera footage within days of the incident occurring. The video reports are selectively edited and narrated by RPD officials, but publicly released to the world nonetheless. The most recent one was a shooting incident on 5th Street. In the video, RPD officer Greenlee basically lays out the city's case, justifying officer-involved shooting. The more than 13-minute video shows police shooting a suspect in downtown, explaining in detail what happened. RPD identifies the suspect by name, and then the city publishes the suspect's image. It defies belief that the city can then later claim in sworn affidavits it does not do exactly what is presented publicly. On the other hand, only to later insist to this court its practice is to never release such material in fear of allegedly jeopardizing the integrity of cases. Thank you.
Thank you, Ms. Grant. Next caller.
Chair, there are no other callers to provide public comment at this time.
Thank you. So with that, then I will go ahead and close public comment. Just a few announcements about tomorrow. Tomorrow we are not scheduled, so our next committee meeting will be at 9 a.m. on Monday morning. And with that, I will go ahead and adjourn for today. Have a great weekend, everyone.